This is Horum with Horum's Quorum. My guest today is Ambika Kumar. When tech or media companies have bet the company matters involving free speech, they come to Ambika. We discussed how she strategically built her career in the space, starting as an associate. This is one of the most direct conversations we've recorded. Here's Ambika. Ambika, I had been looking forward to this podcast for maybe a year. I don't know. It's been a long talking, right? And
It's yeah,
this is
hard to
definitely
find a time.
the longest I've waited to record an episode, and no pressure, but no, it'll be really good. We've just had a number of conversations for some time now, so it's been really interesting to get to know you and your practice better. And so something I'm really struck with is you're very down to earth, but you're also highly strategic. And so I'm interested in I think strategy from our conversations is something that showed up really early in her career, going back to law school, and that resonates for me because I think I was strategic in starting in law school. That led me down the path that I've been on. So I'm curious to hear. It sounds like you identify as a strategic, um, taking a strategic approach to your practice. I think substantively and then also professionally. Let's start with professionally. What is the role of being strategic mean to you? Like, how have you been strategic with your career?
Well, I would think that I would say that I'm strategic in basically all aspects of my life to the extent it makes sense. And so, in the context of my career, I went to Duke University and I graduated in 2002. And while I was there, I was the editor of the student-run daily newspaper. It's probably the hardest I've ever worked in my life. And when I got out of college, I thought about becoming a journalist, and realized that that was not necessarily what I wanted to do, in part because I wanted to have enough income to raise a family in the way that I was raised. And I thought, well, how about I go defend journalists? And, at the newspaper, we'd gotten a couple of demands that we had to talk with our lawyers about. And so I'd been exposed to it from that perspective. Um, I took a year off from college, and then I went to University of Chicago Law School. And it's because I knew I wanted to work on First Amendment issues and issues for journalists. I did an independent study there with Jeff Stone, who's a scholar in the area. Um, and then when it came time to figure out what to do after that, I was researching firms trying to figure out who is sort of the best in the news media defense bar. And there were two that came, sort of that were at the top of their game, and that was Davis Wright, where I am now, and a firm called Levine Sullivan, Koch and Schultz, which was a boutique in DC and New York. I don't remember if they have other offices. I interviewed with Levine Sullivan and didn't get a job. I interviewed with Davis Wright, and they were only really taking associates, summer associates in their Seattle office. Sometimes we take from in other offices with very exceptional cases. And so I realized that if I wanted to come to Davis Wright, I would need to at least start in Seattle. And so I split my summer between Davis Wright and Baker and Hostetler in DC, which also had a media practice, although not nearly as robust as Davis Wright's. Um, and and so, to me, the difference between the firms was night and day, just from a personal aspect, but also substantively, I was doing more work at Davis Wright. So, um, I got married, took the bar, started my job, moved to Seattle, all in the same summer. And I actually wasn't, I thought maybe I would move sometime to an area like the Bay Area. I actually didn't want to be in sort of the media centers of New York, DC, or Los Angeles. I wanted to be at a place where I felt like becoming a partner was a real possibility and did not require, you know, working all day, every day, and sometimes all night. Um, and so I came to Seattle thinking maybe I'll do a little bit of media work. It won't be everything, um, but let me see. And by that time, it was clear that content was moving online. Um, and uh, and we have these tech companies in our backyard in Seattle. And I was thinking, well, we should be doing more for them. I mean, we already did do work for them, of course. But I thought I could find a place there. And between that and the firm's nationwide First Amendment media practice, I was able to build a career. And I feel very lucky that I could do that sitting here in Seattle, which is really not a hub of media law.
How do you advise someone to execute on this? Any number of times a lawyer might see some frontier technology or some convergence of an industry. Um, Practically, this is something that comes up a lot. Like when you talk to lawyers who are early in their careers, there's things that they're really passionate about. Maybe they wrote some out in law, their article for their law review or whatever. There's just some topic that is just some interest in theirs. They're identifying something cutting edge, and they experience challenges with implementing that. It's, hey, I'm just an associate. How do I move my career down this path? I can see something. Maybe everyone can see something, but the partners are embedded with their existing ecosystem of clients. They're not incentivized to build out some new practice, maybe. Um, there's a variety of conditions that make it a challenge to grow in that way. How did you do it? And then what tips do you have for someone today who wants to take that strategic approach and converge their interests with the skills and platform that they're at?
When I came to the firm, it was clear that I cannot do only media work. There wouldn't be nearly enough. It was a very highly sought after group. There was already one other associate in the group who was more senior to me. And so I did just general commercial litigation. And in fact, I had one partner in the IP area, litigation area, who kept telling me, just get general commercial litigation experience. That's what you need. And he was right, as frustrating as it felt at the time. And then when, the firm circulates a list of clients for conflict purposes every day. And so I would look at that list, and a lot of people do this, and I would see a case that had been brought in that I'd be interested in, and I would contact the partner who was running the case and see if they needed help. Um, and I did this with one of my mentors. I did that, and it was easy. We would just start working on it. With another, I think I had to ask him like 4 or 5 times until he decided, okay, I'm going to give her a chance. And then for me, the key was just doing really good work, and not being a jerk as well, being, personable. So, um, over time, I got to know clients better, and uh, I was writing things like that. I mean, I think I was very fortunate to be at a place like Davis Wright, because it is extremely collegial. And I think people are genuinely interested in developing associates who want to become partners. I also happen to be in a group where a lot of the rainmakers are women, and they have children. And so that was for me a model, although a lot of my models early on were men with families and who were invested in their families and who, would say, I have to go do this for my kid now. Um, I think I mean, at the time, Davis Wright was sort of a regional firm. And, and so I think it was less, I don't know how to describe it, but certainly no one was doing document review day in, day out. And people were actually we had a 1-to-1 associate to partner ratio, which meant that the partners get paid less, but it also meant that the associates got the experience of multiple tenures of associates. So they were doing everything from drafting motions to engaging in discovery, and so you saw that stuff and having client contact. So I think I don't know. I can't say what would work today. I do think that finding people who can teach you how to do what you want to do is important, and riding their coattails is important, right? So, one of the reasons I came to Davis Wright was there's this treatise, a 50-state survey on libel law, and I looked at who authored the Washington chapter, And it was Bruce Johnson, who was, one of the mentors that I mentioned, the one that I worked with for a long time. And so I found him in my summer associate days and did work for him. And then I continued to work for him, for years. Um, so, I had a review once early in my career that was, she's too eager and ignores nonverbal clues, which I found to be very confusing. And a couple of years later, the same partner said in front of a group of people, this is Ambika. She's one of the most respected, if not the most respected associate in Seattle. And so what I learned from that was, even though I was being eager, like that ultimately did not cost me anything, right? And in general, I think being eager can only help you. And so showing an interest in learning, in feedback, not eschewing projects that are non-billable. Sometimes that's the best way to get to know somebody, is like they need help writing an article or a chapter or something like that, and you do it. And because it's non-billable, there's more time for sort of, personal, developing a personal relationship, because you're not charging anybody for that time. So, you know, I honestly feel lucky that content and online like just happened. Like I didn't go to law school for that purpose. I just saw it happening, and I just happened to be coming to Seattle, and I thought, well, this seems like a good opportunity, and it was.
Yeah, and I've observed among other litigators, particular that I've had on this podcast, is that I think that's a formula for success is starting out at an established platform and growing in some way into some frontier that has been occupied. Sometimes that is a geographic office, that's a frontier. Sometimes it's a practice area. But it seems to me that that's an asymmetric bet. And as you said, like eagerness is a form of an asymmetric bet, right? Like there's a downside to eagerness. It can backfire. Maybe it makes you look too earnest and naive, or some others. You can dredge up some negative qualities from eagerness, but in balance, 9 times out of 10, eagerness will have some asymmetric upside. So I guess I think this concept of an asymmetric bet in terms of, on the scale of eagerness, on the day to day, or on the scale of your career, that seems to be another concept. Does that resonate with you, the concept of taking asymmetric bets in your career?
Yeah, probably. I mean, I don't have I'm not somebody who can say something I don't mean, or who can't just be brutally honest. And so, um, oftentimes that means doing things where other people would not feel comfortable doing it, whether it's, I don't know, whether it's having an unusual conversation with opposing counsel about, our relationship and how to make it better, and trying to slow things down and make it less, or whether it's knowing what's going on in the personal lives of the people that I work with. If they don't want to tell me, of course, I don't push, but I do take an interest. And I share my own personal life. And so I think those things are probably things that most people don't do, but that have paid off for me, um, in my career and in my personal life.
Hmm. Can we talk some more about the substantive aspect of your practice? Tell me about substantively, maybe going back to your associate days, um, a strategic mindset you took to how you counsel clients, litigation strategy that differentiated you, that you feel like was original, novel, a departure from um, consensus.
Um, my early associate days, I was way too shy and too scared to say anything in front of a client, much less adopt a novel approach to counseling. You know, I I grew up in a culture where, the people that were more senior to me were sort of authorities to learn from and to defer to. And that is how I operated in my practice. And honestly, it's only in the last, I don't know, you know, 5 to 8 years where I feel like I I am that person, right? Like where I sort of know what the right thing to do is or what the, it's just more natural. And so I don't have a problem um, you know, doing it. Like, I had a situation once where um we were counsel for a defendant and there was counsel from a co-defendant and they were at like a one of these top tier, not that Davis Rice, I think Davis is a top tier firm, but often that is not the impression of other people. um, and this more senior lawyer at a different fancy firm was suggesting that an argument that I had suggested was not worth making. And 10 years ago I would not have pushed back, but I did this time. And, uh, I think it's important to, I mean, part of that is getting comfortable with my own level of knowledge and strategic insight. And some of it is um, not being discouraged when somebody who is more senior to me and is a white guy, says something to me that, it doesn't, I mean, that didn't resonate and felt condescending and felt like I wasn't being taken seriously. Fortunately, I have clients, right? And so clients, they get it and they know that I'm good. And so I think, in terms of novel approaches, so I'm very direct. I do not overstate our chances. If anything, I understate them. I don't want anyone to be surprised if something bad happens. Um, I tried a case many years ago, early in my associate years, and the partner in the case thought we were going to win, and I was like, "There's no way we're going to win." And I had to be really careful about what I said. And you know, and sure enough, we didn't win. But anyways, so uh, you know, I send short emails. They're not long. And this is like not novel, but like I do see a lot of people at other firms just sending these like, 4 paragraph emails. They're not memos because I think memos are mostly things that clients have decided they don't want unless it's something really critical. Um, but they also don't want like to have to read, 20 sentences if it can be said in 5. And, bullet points are helpful, bolded headings. Like if you're like looking for like a part of an email that talks about, our motion to dismiss, there's like a little heading that says motion to dismiss. Um, I find that helpful. I also increasingly believe in talking to people as opposed to emailing with them. Feels like it's becoming a lost art, but I have one mentor in particular who was like, just pick up the phone and call. Like, why aren't you just doing it that way? And I think there's a couple things about that. One is um, people can be different in writing. They're much more comfortable um, acting in a way that you would never see them act in person or on the phone. Um, Also, you can read the tone of voice as opposed to reading tone of text. You can't always do that. And you might learn more. I recently had a situation where one of the one of the lawyers I work with, he's like, I'm going to send an email that blah 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 blah. I was like, why don't you call her? Because then you will get more of insight into what she's thinking. Um, and he came back and he said that was a good call, because I did. Um, and so, I mean, that's not client facing. With clients, sometimes it's easier to talk through something because otherwise you get spun up in this like churn of emails. I've had that where I've been co-counsel with another, again, fancy firm, and um, the client calls me and says, like, I'm really frustrated by this like email exchange. Like, I feel like no one is hearing what I'm trying to say. And that's just a lot easier to convey. And it's easier to cut to the chase on a phone call.
Are you saying the client was included in the joint defense group exchange?
No, this was my co-counsel. Like, so
Oh, I
they
see.
also
Hmm.
counsel for the client.
Hmm.
I often get paired with larger firms, closer, higher up on the AmLaw scale, to provide my expertise on various, you know, issues like the First Amendment and Section 230. Um, I also don't, I'm also really honest when a client asks me, do you have this expertise in your firm? Like, it does me no good to be like, yes, this person who kind of has experience. Like, if I recommend someone, it's because I know that they're good. And so I just pitched a case where, um, cases in a state where I don't often practice. Um, State officials are involved on the other side. And I pitched it and I said, you're going to really need to pair us with somebody who knows these people. Um, and things like local counsel, they're critical because they have the day in, day out experience that you don't and can't have, to let you know, uh, any quirks about the judges, anything, any particular views they might have on the issues in the case. Because a lot of my cases are, um, you know, politicized, especially these days because tech companies are, you know, in the limelight.
Is your observation, do you think that the importance of local counsel is more important state or federal court? Do you have a point of view on that?
I mean, probably state, but I think it applies to federal court. It depends on where you are, right? Like if you're in rural Texas, it doesn't matter whether you're in state or federal court. You need somebody there. If you're like, if you're in New York, way less of a concern. You should still have somebody there to ask base, but it doesn't have to be somebody. And it depends on the type of case. If it's a case that requires a particular expertise that involves knowing the procedure of the court or the judges on the court, like, that's important too. But if it's a run-of-the-mill piece of litigation and it's in a major city, local counsel to me plays a lesser role.
Hmm. Can we trace back to what was that path from commercial litigation to some of these high stakes tech and speech disputes? And part of the question is also, I mean, you initially were very interested in the media tech litigation and you're representing journalists and now you're representing platforms. Can you talk about those two evolutions in your practice?
Yeah. I did represent journalists for a good bit of time when Washington had an anti-SLAPP statute in particular. The news media had the resources to pay for their defenses and knowing that they would get their fees if we won. Um, that statute was held unconstitutional. I don't know, it's been at least 10 years. And that work kind of died off. And the reality was, being in Seattle, I was never going to be like a premier journalist defense lawyer. It's just something I had to give up. And frankly, something that's extremely competitive. Not to say that the area I work on is not competitive. I mean, it is, but it wasn't. When I started, it wasn't as competitive. It didn't feel. I think that, if I saw the firm was litigating something related to content, I went after that case, went after the lawyer, asked if I could help. And the more that I did that work, the more exposure I got to other clients with similar work. And those clients happen to be, platforms. But, I've certainly had help along the way. Other work has been referred from lawyers that I work with, which is, flattering because it suggests they think I'm a good lawyer, but also that I'm, relatively easy to get along with, at least in the professional context. So, um, so, um, I think what else? I mean,
Maybe.
I would go to conferences that were around the subjects but they weren't like my main, like never did I go to a conference and think I'm going to get work from this or,
Hmm.
this is really going to significant. I mean, you have to go to them repeatedly. You have to see people year after year. And you also have to rely on on partners to introduce you to people, which I had. I had one person who would be like, you know, look at the RSVP list and tell me who you want to meet. I will introduce you. And those things are really important because they're just the seeds of something that can grow later.
In picking up this clientele and starting to get experience in First Amendment, Section 230, I'm curious, what was the inflection point or inflection points in your career? Like, what was the first inflection point in your confidence, skill set, the stakes of the matters you're working on, in that space?
Um, it's, I mean, the first high profile matter on which I was lead was the first TikTok ban. Before that, I had worked on cases that were important and prominent and written about in the news. But I was usually a part of team. So all my bio description would say, part of a team that, or, you know, that kind of thing. So it's really just been the last, 5 years that I've felt this confidence. I mean, it was growing, right? It was like, it wasn't like a switch. You know, uh, I got increasingly comfortable pushing for what I thought was the right decision. Um, and I think when I got, there was like this MVP award for media and entertainment, a few years ago that I got that, then I was like, wait, like you know, maybe I have a profile that's not local or tied to someone else, but that is just my own. Um, and then the Wall Street Journal, after the first TikTok case, wrote an article in which they said they hired top First Amendment lawyer Ambika Kumar, and I was like, "Whoa, that's crazy! Is that me?" um, and uh, and so those things have certainly helped. And what has helped the most, probably, is the reassurance of the people that I work with that who are much more senior to me, who when if I'm ever slow, which yes, it still happens, are like, you're gonna be fine. Like, go take a vacation, take the day off. Um, you're gonna, from when I was an associate, you're gonna make partner, you're gonna make equity partner. Um, I didn't have the confidence. I only went up for partnership, and this was the year after my first son was born, because somebody said, I think this is your year. And I said, really? Like, I just had a kid. Are you sure? Like, and he's like, yes, I think this is the right time. And I did, and I got it. And then I went up for equity partner uh, the year after my second child was born. I can't remember, somewhere around there. Um, and so, part of it is like the firm has supported me immensely over the years in my career development and trajectory. Um, and when I will never bill as much as I did before I had kids. It's just not going to happen. And I don't want to. And I think that Davis Wright's willing to make investments of that sort, knowing that I'd established a reputation. I was really hardworking. I was good at what I did. I had a kid. Of course, my hours were going to drop. How much we'll see. And I went through a divorce while I was at the firm. I never felt like pressure from the firm to um, minimize my personal commitments in order to bill more hours. And that's been easier the last few years because I generate business in addition to like actually doing the work. And so um, generating business isn't as time, doesn't cost as much time, right? Like, you've got a reputation, you write a client, you say, I saw this was filed, would you like help? And then over time, like maybe, 10 years ago, the chances I would get it from just that are minimal. And as time goes up, they're much higher. They're still not like super high or anything, but you know, there are now times where a major company, I pitch for a case and I feel like it's like a 50-50 shot, which actually feels like a pretty good shot.
You have a couple really wild stories in, I don't know if you consider them inflection points, but just maybe maybe you do. Maybe they're just like, just tangible career catapult moments. But I'm thinking of the first one I'm thinking of is a TRO that you
Yeah.
argued at 7:30 in the morning on a 2 hours notice. Can
Yeah.
you share that story?
Yeah. It was a Friday in 2020, I think September. So 2020, I would have had no, not 2020. It was earlier than that. I don't remember when it was. My kids were small. I had two small kids. And so they wake up early in the morning and sometimes in the middle of the night and all that kind of stuff. Um, and President Trump banned TikTok. Times have changed. And or maybe times haven't changed, and he hasn't either. But um, we got the executive order, and I wrote a TRO motion in a day, working with one of the litigators, and then just filed it that day. And I went to bed feeling like totally, it was one of those days like I was in my pajamas all day long. I didn't eat very much. I was just focused on getting this done. Um, and, so I was relieved to go to bed at night. I was like, oh, I get to sleep now. And like many people, I have a bad habit of looking at my phone sometimes when I shouldn't be, when I'm like, I should just go back to sleep. But that habit was reinforced because at like 6 or 6:30, I looked at my phone and I saw that the judge had set a hearing for 7:30 Pacific, 10:30 Eastern, because the case was in Pennsylvania. And I was working with a couple other attorneys, one of whom was much more senior to me. And I called him and he said, I was debating when to call and wake you up. And so he said, so it's good you're awake. And this was, yeah, well, it must have been 2020 because it was during the pandemic. And uh, and I went down to so it was a virtual argument, like one of the first ones I did, or maybe the first one. So I went down to my basement, like trying to figure out, like, I don't actually work at a desk at home. So like that was not an option. So I set up this crazy, like, area where I had a side table with a box of like a fort building kit box on it with my laptop on top of that. And my seat was the back of an exercise bike that had been torn to shreds by the cats that we had. Um, and of course, I did not have my actual like background, like I had a fake background. Um, and we had the hearing. It was a lot of fun. But and then I was done. And I was like, okay, back to my Saturday life. I can't remember if we got an order, but it definitely was a hearing that went well. And unfortunately, the government lawyer, unfortunately for the government, he had been like, I think he'd been out of town or something and hadn't even seen the papers really. And so I felt bad for him because it's not like he knew the record very well. He couldn't know the record very well. Um, and we got an injunction eventually. I don't remember if it was from that hearing or another. There was one that was, I feel like she said it was premature or something like that. So yeah, that was crazy.
And then wasn't there also another Saturday injunction hearing in another matter?
I
I'm
don't think so. You might be thinking we represented AWS in a lawsuit brought by Parler. Parler is was a social media service on the right, you know, sort of politically. Um, and this was after January 6th, um, before the inauguration. And, it was made headlines. AWS suspended or restricted Parler's account. And then Parler saw a TRO that would require AWS to restore its service. Um, that one I remember, I was going through a divorce and I was staying at a friend's house, and I remember pacing the halls at her house, practicing my argument. Um, there was a lot of prep, including, with other lawyers and including the client. Um, so I remember that one vividly too, because it was also very fast paced. And I was not even in my own house, and it felt odd to just, and it was pandemic, so I couldn't go to the office either. So I was just sort of in this, like, visiting and the friend whose house it is, she was gone, so it's just me and my dog, my pandemic puppy. Um, and I just paced the halls and practiced my argument. And then I did my argument at a side table in her bedroom, overlooking the water, again with no background. um, but I mean, pandemic definitely put me in some odd places physically to make arguments. It was kind of fun actually. It started like thinking like, should I try to make sure I do it in this kind of room or that kind of room, like the kitchen, Um, so
I want to pick up on, you're talking about your kids as part of your team and the timing of the kids, and it seems like kids are your lucky charms. Just, if you want to level up in life, have a kid, I guess it sounds like. Um, do, do you feel like having children has influenced how you practice? You mentioned, not billing as much, but, focusing things on things like, you are by now if you accumulate a reputation, so then you can focus on business development, which is high ROI for the amount of time involved. Is there a strategic dimension to having children? And I had a recent interview with Laura Kerslich. She's a litigator at Goodwin, and she talked about the ways that having children for her has made her more strategic as a litigator because in the past, she would take on every aspect of a case and enjoyed, owning every aspect of the case. And now she realizes she has to take much more of a team's approach and say, who is the best person for handling this aspect of a case? So I'm curious for you whether you feel like having children has influenced. I keep on using the word strategy, so you can ignore the word strategy or supply some other word. Influence how you practice. Like, has there been some sort of reciprocal relationship between having kids and how you practice?
I mean, definitely I delegate more. That's a consistent theme. As one should as one grows more senior, but it's much easier when you have kids and then something else you have to be doing. It's a hard skill to develop, and it's one that I try to tell people I work with, like try to help them, like, why are you online right now? Go. And uh I think that having kids can change your personal interactions in a way that can be, I suppose, advantageous in the sense that, some of the cases I work with are about tech companies and children. Having children gives me that grounding of, thinking about like, should my children access social media? If so, at what age? What restrictions should be on there? Should I be able to see everything? They're little right now, not little, but they're not of an age where they can reasonably demand privacy. And so, some of those issues are still coming. But I think um, there's something about having children yourself as opposed to having a colleague that has children that um, just changes your perspective, I think. And I talk to my kids about work. I practice because if I can explain it to my 12-year-old, I can explain it to a judge. Um, he will ask good questions. Um, Client development efforts sometimes involve family now. I've taken a client and his son to a hockey game with my son. Um, it sort of, so that part has changed too. I have a lot of female clients and there's a lot of conversation about our kids. It doesn't feel gendered. It feels like this is just my life. And uh, and so I can't say that it's helped me develop business in any direct way, um, except through friendships with parents I've made of students in the same school, for example. Like that certainly has happened. Um, but otherwise, I stopped working on the weekends, for the most part. And I try to make sure that other people on my teams aren't working on the weekends. Um, I always tell them, if you can't make a deadline, please check in. It may not be a firm deadline. And we might be able to, oftentimes like I have a deadline for someone to get me something and then I'm like, uh-oh, I'm busy with this other stuff. Can't review it right now. And so I'm just like, take it back. If you're not done, like, feel free to work on it some more. Um, but um, yeah, those are the ways in which kids have changed my approach.
And then you mentioned, you know, tech views around, the challenges that tech companies are having now around privacy, around um, addiction, different aspects of social media use for children, and questions about that. Like, how do you reconcile, the needs of a client and your personal views around, how you want your children, um, what they want to have with social media and what you expect from a social media platform. Like, how do you reconcile those two parts of your life?
I don't think there's a lot of conflict between them. I really do believe it is my job, um, not the job of the law, to to teach my kids what social media is, how it should be reused responsibly, whether it should be used at all. I mean, my kids, I mean, I haven't reached this point yet, but like, should they want to engage in social media, I'll help them navigate it, you know? And I do wish sometimes that on some services I had better tools to limit, for example, limiting access to specific like types of content or specific content while allowing others like that. It can be hard to customize it. And part of the problem is that because as a society, we seem focused on making the platforms responsible for what children see um, online. And um, I've seen some arguments that are really like, I don't want to say frivolous, but they are not good arguments. Like, you know, I had one case where the client's terms of service said something like, it was an adults only platform. It made that clear. It said by, entering your date of birth, you're certifying that you're over the age of whatever it was. Um, and then in a separate part, it said people under the age of majority or minors may not access the service. And one of the claims in the case was that means you guaranteed in your terms it was physically impossible for children to access your service. Like, it's just a completely unreasonable reading in the context. What it means is you are not allowed to do so, not you physically can't do so. Um, and I wish, I had another case where the other side was adamant that my client should be able to verify the ages of its users. Now, age verification is not like, flip a switch and it's done. It can't be. And it also has serious privacy issues. That's not to say that one day we might not get to a place where like that is a thing that we do. But we're not there yet. And I remember asking opposing counsel, I said, what is it that you want us to do? Like how, like it's not possible right now. Like, and the response was, that's your problem, not mine. And so I I wish that we had a more cooperative relationship with the people who have these concerns. We being like, you know, I wish the tech companies and government could work together on things as opposed to just, you know, I think it's different in Europe. Here, it's very much like we're going to pass this law and then we're going to penalize these guys and um, until they comply. And often those laws are unconstitutional and it's counterproductive to be overreaching because then the real problem is still there, right? Um, like I really do want, parental controls that are more tailored. I can make more tailored for my kids. I could probably go look for one and probably find it. But it sure would be nice if it was like advertised or the government was like, here are some ones that we think are good or what have you. But I don't, yeah, in some states they do have that, not that specifically, but like education for parents. But it just doesn't seem to be, it doesn't seem to be the dominant way that people attacking tech companies think about it. I'm a lawyer for in some of these cases, alleging that video games are addictive to children. My children play video games. And once again, when I see in some of these cases the number of hours a child and the age at which their child, like so and so started playing at the age of 3. So and so spends, 15 hours a day playing video games. Like I'm sort of just wondering, like, what is going on that has made this possible and happen? My kids play video games too much. I don't like it. And it's a constant struggle. And now that they're getting older, I can at least explain why I don't want them playing video games as much as they are. Um, but they're not playing, they didn't start playing at age 3 and they're not playing 15 hours a day. And I can't fathom that ever being the case.
Hey, like you can watch with some frequency. At this point, it's become daily. Like, videos of garbage trucks and construction. Those are the two
Yeah,
ones.
love it.
And then we also pair it with, and I have mixed feelings about this, pairing it with meals because I've observed, just like an adult, you're more likely you eat more when you're
Distracted. Yeah.
distracted, enjoying something. And so, he eats pretty well as it is, but then we'll, put that in front of him.
And he'll
Uh,
just be like, yum. Yeah.
totally.
I mean, one of my kids, I learned in therapy with him. He was in therapy and the therapist has these like fidgets everywhere. Fidgets were not a thing when I was growing up. Like you did not, it was like you should not be paying attention to something else or messing with something else while you're also paying attention to a conversation. And also at my kid's school, the head of the intermediate division, who's a good friend. I mean, she's no longer in that position, but her office was full of them too. And I was like, oh. And one day my son had a fidget he was taking to school, and the nanny was like, do you really want him to take this? And I was like, I don't know. And so I asked my friend, I was like, what do you think? She's like, yeah, like, and it's permitted in school. And that's because if they have something that they're doing like this, and I find that I am the same way, I pay better attention. And in therapy, talking about painful issues is easier if you're like throwing a ball back and forth or doing something that takes takes the sting away somehow. And um, so with my kids, I feel the same way about drinking. Like I'm not certainly not there. He's 12. He's not going to be drinking alcohol anytime soon. But at some point, I will introduce it to him um, to make sure he knows how to do it responsibly. And that's all I can do. Like I view my job in the world is to turn them into happy, good people. And part of that is knowing how to navigate the world as an adult. And we got him a watch when he was 9 or a phone and maybe 10. And he doesn't play games on it. It was because he's an anxious kid. And when I was late to pick him up for something, he would just be terrified. And maybe that's something you should have to learn, but like in this day and age, you really don't, right? Like as an adult, like you just text and you say, hey, I'm running a little bit late.
Yep.
And so, you know, gave him peace of mind and it made me less guilty being late to places because I knew he would
Win-win.
know from me that I was just running late.
Yeah, and so I'm curious, in your work seems very distinct to me in that I was a patent litigator, and so the relevance of public opinion is fairly low. To be fair, most of my work is bench trials, so I was
Yeah.
far less opposed to popular sentiment, but your work is virtually inextricably linked to public sentiment. So I'm curious about, I've never had very satisfying explanations for our relationship with tech companies. Maybe the best analogy that I can make is, growing up in the 90s and 2000s, a lot of the backlash was towards companies like Walmart, which clearly most people used, but then had these very ambivalent feelings about and just also hated. And so they're the target of public ire, or like, McDonald's, let's say, with what was that documentary I'm thinking of? But Supersize or whatever. So with tech, I'm curious to hear from your vantage point. I mean, you've been in Seattle for a period of time, and so you've seen the growth of tech companies there. Seattle's had this kind of its relevance in tech has kind of fluctuated over time and kind of just gone this like, very
Yeah.
spiky process of upward and then down and then much higher. And so it hasn't been like this steady. And then also public sentiment on it, I think has been kind of mixed in terms of like how much we love it or hate it. So I guess can you speak to how the role of sentiment, tracking sentiment, being strategic around sentiment, policy, like how does that play into your work? Like how do you weave legal reasoning, um, strategy? I'm trying not to use your strategy. I know I've already blown my budget.
Okay.
With this sort of sentiment component to your work. It seems to be a really unusual way to really unusual form that influences your practice. I'm not sure how.
Um, well, look, the clients are businesses, and what's good for the law is not necessarily what's good for the business. And so, when advising clients, I think it's important to understand what their goals are. And in these cases that are very high profile and very, have very disturbing facts, there are strategic reasons to do various things. For example, sometimes um, clients have an arbitration clause, and the reason for that is so it doesn't have to be litigated in the public sphere, right? Um, I think the popularity of arbitration clauses has waned over time to some degree, for a variety of reasons, but um, some clients just won't make an argument because they think, I think, let's see if I can say this. For many years, I think some companies were reluctant to use the First Amendment in a way that said, we didn't know this content was on our service, and so we're protected, because they viewed it as, um, for basically saying we have a First Amendment right to have this smut on our service, right? Which is not that different from what Section 230 says, but the result of that was that Section 230 took off, um, and there was a lot of law developed in it, and the First Amendment law stagnated in the tech sector until people were like, "Oh, we better pay attention to the First Amendment too," culminating in the Moody Net Choice case. But because I come from a firm that has such a strong First Amendment practice, um, I think a bunch of us felt long ago that, like, it's sort of foolhardy to rely only on Section 230, which can be repealed, to the exclusion of the First Amendment, which is, one would hope, never going to be amended. So um, I haven't, interestingly, I haven't had people like sort of ask me, how do you do this work or things like that. I think um, it's interesting that either your comments about Walmart and McDonald's, I'm trying to think how analogous those are. I think so. Walmart, you only go to Walmart if you need something. You only go to McDonald's if you need to eat something. Technology is the source of everything in some ways, um, and so there is no way, even if you didn't want to use Walmart or McDonald's, you could do that, but you can't not use technology really, and function, in society. And I grew up in the 80s and 90s where I hadn't, an analog childhood. There was none of this. And so there's good things and bad things about it. And, um, you know, I think the important thing is the important thing in any case in this field or not is to tell a story that's compelling, to have a narrative that's going to resonate with the judge, because judges fundamentally want to do the right thing, right? They want to, you know, they want to be able to find a doctrine that tracks what they think is the right result. Um, and so whatever you can do to give them peace of mind that if they dismiss a case, it's not going to be the end of the world for another set of plaintiffs, or, um, really the client is a good actor, and these are just bad facts. Um, Sometimes these cases involve children who've died by suicide. Um, those are very hard cases because the harm is so great, even if it wasn't caused by the tech company. but by third-party content or what have you, a host of factors. And those are cases that, you know, I have a different approach in cases like that in terms of, whether to settle, when to settle, what arguments to make, because the reality is in the law that suicide is an intervening cause that generally gets rid of liability for, the tech companies. But we don't, it's not like we're going around, like, I don't go around saying, like, let's say this, it's kind of not, it's not an argument that, um, it's not an argument that appeals to one's sense of good and justice and fairness, right? Um, what might resonate is these are the specific circumstances of this child. Here are all the things that were going on in their life. Here are, that kind of thing. And so, but that needs discovery a lot of the time. So it's hard.
Can you, just on a substantive point, can you go back and just, briefly explain the relationship between Section 230 and the First Amendment jurisprudence in, say, the past 10 years? And I know that's a big question and a lot to explain there, but for people that are, it's obviously a hot topic, but
Yeah.
a lot of people, maybe they saw some dry summary of a Supreme Court decision recently and just,
Yeah.
just eyes glazed over. Uh,
Yeah. Yeah. Section 230 was passed in 1996, and the purpose was, at the time, we didn't really have the internet. I mean, we had the internet, but most of us did not. And um, at the time, uh, the at common law, arguably, a service could be like an AOL or a Prodigy could be responsible for the content that it hosted that other people posted. And Congress didn't want that to happen. Actually, Congress passed an omnibus law that was like, you can't send harmful content to minors, but also here's this like exception to liability for third party content. And most of the law was struck down, and what survived was Section 230. And so over time, it has been expansively interpreted to protect uh, publishers that host third-party content that allegedly is harmful. And it has been litigated a lot in the last probably 15 years because it is such a strong immunity. And, it's one that kills lots of cases. And so it was designed to foster the First Amendment on the internet. It was designed so in the brick and mortar world, in First Amendment land, if I'm a bookseller and I have obscene books in my collection that I'm not aware of, I'm protected. If I know they're there and I know they're unlawful, well, I'm not protected. With Section 230, it doesn't matter what I know or don't know. And the reason for that is because when a service polices its own content, um, it is incurring a risk of liability because then someone can come and say, okay, you vetted your content, but like you left this one out there. And the number of messages that we're talking about was just staggering. And so what Congress did was say, okay, you're just not going to be responsible for that. Like you're going to self-regulate, police your own services, and no one's going to be able to come after you and say, you missed this one piece of content, and so you're liable. And so they are complementary of one another. And I think people don't always understand that. I frequently get the question, how can you say that your client's a publisher but also entitled to Section 230 immunity? And the reality is that Section 230 immunity applies to publishers. Like the answer is these publishers won't be treated like publishers at common law if the harm is stemming from third-party content. But it's not necessarily intuitive. And it does require an attention to detail. And I think that state legislatures down to municipal, governing bodies, they're not concerned with the details often, which as a citizen, I find disappointing because I can't, if I were in government, I could think of much better ways to do regulation in this area. And I'm sure that's true in all other areas of my life. Um, and in this area, at least, whatever is politically popular is what's going to happen. And that's not always what's most logical result.
mhm. And then And I'm sorry if I didn't understand it fully, but then what was the relationship with the First Amendment jurisprudence? Like, how did that, now it
Yeah,
says,
so the First Amendment, as I said, if you were the relevance is that the First Amendment was being applied in the brick and mortar world and not on the internet ever, really.
Mhm.
Even though there were principles that we now know from the Net Choice Moody case, which made clear. I mean, there was this reluctance to treat online publishers the same as brick and mortar publishers. This idea that tech companies and tech services and social media services were somehow different. And so we're not entitled to the same protections, even though what they were doing was the same thing that publishers have been doing for, a long time. So there's a case called Tornillo, I can't remember if it's Florida Star or something like that in the Supreme Court, where some negative thing was written about a politician. And I think Florida had like a right of reply, like requiring the newspaper to host a response. And the court said, no, no, no. Like what messages you include, that's your, you have that right. And the same is true with social media and tech companies. They have the right to decide what mix of content is going to be on their services, to figure out what kind of communities they want to create, what they want to tolerate, what they don't want to tolerate. It's all about organizing content. Um, and so the First Amendment principles apply equally to that as they do to Section 230. But because people were reluctant to make those arguments, Section 230 kind of predominated for a while. And then when politicians were like, well, maybe we should get rid of Section 230, people came around and started making more of the arguments. And as I said, that culminated in the Net Choice case, which held that, services that are arranging, editing content, et cetera, are publishers under the First Amendment and entitled to, the same protections.
Yeah, I can't remember where I read this years ago, but it is pretty fascinating that uh, somebody made the assertion, and I haven't disagreed with it since then, that media businesses are fascinating because the existence of the business is constitutionally protected. That it's hard. I can't think of another business model that's protected by the most core tenets of our
I
government.
mean, the gun industry is protected by the
There you
Constitution.
go. That's the one. Um, can you speak to so an obvious uh, we, early in the conversation you were talking about identifying a change in technology that a body of law is going to be applicable to. And so you recognize that tech companies are becoming publishers, and so there's new terrain to be new clientele to work with that are in your backyard. So you saw those conversions happening there. Very obvious convergence is now AI. That's this new frontier that potentially Section 230 First Amendment applies to, and some disputes around that. How are you thinking about this new frontier?
I mean, $1 million question, $10 million question. I don't know. Because the firm represents content creators and traditional publishers as well as tech companies, we see the arguments on both sides, right? And for the most part, on some issues, we just stay out of the fray because we can't take positions that are inconsistent, very inconsistent between those two. And so, I mean, it will be really interesting. I do think there is a chance that at some point, I don't know when, the Supreme Court um, decides that AI, information generated by AI, is subject to lesser protection than court protected speech. So commercial speech has less protections than non-commercial speech. I could see the court saying, same thing here. Like, and the reasons for that in the commercial speech context, the idea is that commercial speech is more robust, that people are, companies are going to advertise. They're not going to be chilled by regulations of advertising because it's to their benefit, extreme benefit to advertise. And I think probably there is going to be some kind of similar analysis that, the generators of AI stand to benefit from improving on AI. And so maybe it will always exist. It'll never really be chilled. And so the reasons we afford protection to political speech, which is much more easily chilled, don't apply here. So I haven't seen that argument made by anybody. I, I could see making it, but it would have to go up very high in the appellate courts to really gain any traction. And much like we were just at the beginning of Section 230 and the First Amendment stuff, 15 years ago, I think we're just at the beginning of whatever this is going to become. And I don't know what it is, because the other thing is AI is always evolving and changing, and it's not something that's fixed.
Is there anything different you see about the ecosystem of AI businesses versus the tech businesses you saw, some years ago, and the impact that would have on, I'm just thinking about young Ambika Kumar today, like what would she be seeing as, hey, like how do I create the opportunity at my platform to be servicing either the copyright holders or the AI companies? How would you be thinking about, is there something different about this ecosystem or conditions today, maybe at law firms as well, for how someone, you, at the stage that you were identifying this opportunity, would act?
Um, well, I'd be thinking about who cares the most about this. It's content creators, it's uh, you know, content generators, but also content users. And I think there's probably some room for growth in the area of helping companies who want to make use of AI. I'm just thinking right now, like I read an article in the New York Times the other day that, or maybe it was Washington Post, something about AI and medical advice, right? That like, identifying cases where somebody was able to find a treatment for whatever they that had not been identified by their doctors. That seems like a really beneficial thing. Uh, and I have actually used such technology, even though I'm the daughter of two physicians. And I don't know what's going on in that space, but it wouldn't surprise me if there are copyright issues, if there are, um, issues on relying on the advice, even though there's probably a disclaimer somewhere that says you shouldn't rely on this, like, someone's going to be like, I relied on it. And I think every industry is having to figure out how to integrate AI. And so there will be a range of claims from like employment claims, like my reviews were generated by AI, to, you just saw that the California bar admitted to having some questions generated by AI for the bar exam, like, you know, um, uh, to medicine, like I mentioned. Um, I'm sure it will affect every industry. And I guess I wouldn't be so focused on the tech companies, even though I live in Seattle, because it's going to affect more than just them. And it's going to be in areas outside the copyright context too. Um, Although that will be an interesting thing to watch. And then there's a question of how does Section 230, apply to AI? When I pull up, I mean, this has already been decided, but like, for example, like when I pull up a map and I'm looking for, I don't know, like tailors in the city of Seattle, and I get like a few options pop up, what if it's wrong? Um, is that the service's fault for giving me the wrong information, um, or not? And so we know that that kind of thing is protected by Section 230 because it's been decided at the circuit court level. Um, but that's just a form of AI, right? It's a form of taking information and putting it in a different format, and um, and maybe even like, recommendations are a big thing right now. Uh, so yeah, I don't know that I have a specific area that I would practice in or look for, but um, the news is just as good of a source as anything on, what's coming.
And I'm wondering for you, you mentioned, hey, when I'm in a position now where I can pitch, and maybe 10 years ago it would have been a long shot, but by virtue of having serviced some of these companies and clients, and your reputation maybe with clients you haven't represented or companies you haven't represented, um, you've boosted the odds of getting this work. How do you, it seems to me that someone in your position could be balancing two different things. One is picking up work today where just there's, you have an opportunity to you've got a set of tools that of course expands and skills expand and the law changes. But you've got a playbook to apply to companies. And so you could just run that playbook, or you could be spending more time thinking about the evolution. You're doing some of this, right? You're talking about some of the evolution that you expect of either jurisprudence or pervasiveness of the technology and who would impact, who are potential clients, potential people that could be affected by laws, and spending more time identifying some frontier of your practice. It seems to me that there's some sort of balance to be had between frontier work for you and executing on that playbook that you have today for clientele. Does that sound right? Is that something that you balance?
Yeah, I mean, for sure. I think it's kind of scary for people who are used to doing one thing for a period of years to think about a big jump to something else. And it's not a big, huge jump, but it is a jump. And lately I have been feeling a little bit like, see, I mean, I like my work a lot, but a little bit like more of the same, no variety, and wanting some variety. Um, and that could be a place where it comes from. But I think that I have a very specific focus in and passion in terms of the First Amendment and dissemination of information that keeps me in this like sort of like I don't want to do employment work. I don't want to do, class actions that are not related to my field. I mean, there are a lot of general commercial litigators who are fine with that, but it doesn't drive me to do anything. And so uh and maybe you've identified where I am right now. I've got existing work, but it's where there's this prospect elsewhere that I think about, but haven't really done much to engage in and get work in. And I think partly because maybe at this stage it's counseling, it's not litigation. Because I mean, it is litigation in some senses, but like we're just at the beginning. And so there is probably a lot of counseling that's being done. I know there was counseling being done by my partners, for example. Um, and the counselors are not always the litigators, and that's true in companies as well. It's sort of how it's odd to me because um, it seems to me that like when you're building a product and you want to know the risks of litigation, that like a litigator at some point has to be involved because there are things that we see, you know, we're used to reading something and turning it around and making it seem like it's something different. Um, but obviously that can't be the rule in every product that's developed, and clients do consult litigators, of course, um, but it's a much smaller group of people than the people that are litigating these issues.
Mhm. On that topic, how do you get, so you're talking about how people can get counseled and understand risks they don't understand. How do you do that on the scale of your team? How do you get new ideas from your team? Or can you point to matters you've worked on where someone that was on your team that you manage presented some view that was contrary to yours that you adopted? Like, how do you get new ideas into your work?
I don't know that there's ever been like an idea that I ultimately disagreed with. There've certainly been ideas that I'm skeptical of. There's also new arguments that, I'm pleasantly surprised someone has come up with that I think are really good. Um, I mean, I'm a firm believer in, two heads is better than one. And so I do a lot of talking with my team about various issues, talking out loud and or in messaging, uh, sort of what makes the most sense here. Because there are many calls in litigation that are not easy. Um, and I tell my clients that too. I'm like, look, this is not one I feel strongly about. Here's what I think, and because they should be participating too. But clients also provide new ideas. They'll be like, and like ones that I never thought of, like, well, maybe we should phrase it like this, and uh, but usually if a team member disagrees with me strongly, they'll be able to persuade me or I'll be able to persuade them such that we're never really on a different page at the end. And that's because my team is awesome. They're smart. They're open to discussions of different viewpoints. Um, hopefully they've learned from me, I mean, I think the priority is to serve the client best, and we understand what the client's goals are. Um, there's room for disagreement and approach, but there's, you know, very little that, I mean, not always, but like, yeah, there are certainly times where I'm like, that is a dumb idea, but they're not usually coming from my team. So, um, uh, you know, new ideas also come like when I do appellate arguments. I have moot arguments with outside counsel from other companies, which like sounds a little daunting, right? Like, not from other law firms, rather. So like, here I am doing a moot with my client for like, a circuit court, and here are these other lawyers that are basically my competitors helping me prep in front of the client. And actually, client suggested this to me one time, and now I'm just going to make it a practice if I can, from a cost perspective. And it's super helpful because you've been embroiled in this litigation and you know what you think, but like you don't know what somebody fresh to the case thinks. Um, and so, I don't often call, my competitors and say, what do you think of this? But, I'm not, wouldn't put it, it's not out of the realm of possibility on certain things. So, um, oh, I mean, I often ask the general commercial litigators, what do you think about this? So, I'm always soliciting input. And I think that's one thing the team likes about me is that I like to vet these issues and not just sort of be like, this is what we're going to do. Um, and hopefully that gives them the ability to raise, whenever somebody's like, I have a dumb question, I'm like, don't say it's dumb because you're not dumb and it's probably not dumb. Yes, there are dumb questions, but they're very few and far between. So, I want you to raise them. Um, and I think particularly with women, we're not taught to have as much confidence. I think that's my anecdotal experience. And so the chances that I'm going to hear I have a dumb question from a woman versus a man are much higher. It's not that men don't do it, they just don't do it as much. Um, and so I will tell the women on my team, like, don't do that. Like, you're smart. Like, and people did that for me, they would, like, I remember one of my mentors, who was like probably one of the best travelers in Seattle, once put in a review that I needed to be able to speak up more in front of clients because I had some value to add. Um, and I want people to feel that way because I'm not, if I'm working with them, it's because they do have some value add. Um, and I'm looking to squeeze out as much value as I can for the clients. Um, because my goal is to often it's not to continue their litigation, it's to get them out of litigation, in a way that's consistent with their goals. And so my goal is not, I mean, in some ways, it's self-defeating in the sense that, law firms have historically prized billable hours, but my goal is to spend fewer hours on my cases and have my team spend fewer hours on my cases. Um, just, enough to do a really good job and get rid of it, whether it's through a motion to dismiss or summary judgment um, through a settlement of some sort. So I think that's where I get new ideas. Um, sometimes it happens in casual conversation with friends, say something and it'll make me think.
On the topic of, so you mentioned this mooting approach, and of course, it's only, when there's an argument to be made, at that point in the case. Is there anything you're doing on any hygiene you have on a weekly or monthly basis with you or your team that you think differentiates you or makes you particularly skilled as a litigator?
I mean, uh, I'm not one for formalized processes. Like, just to give you an example, I had an assigned mentor and then I had other people in my life as a junior associate. And I cannot say my formal mentors were even close to being as helpful to me as the people I worked with closely. And I would say the same thing about probably like, I mean, would it be a good idea to have a weekly or monthly meeting or something like probably? But the reality is I talk with these people all day, every day. It's not as if like I go off to a deposition, I'm gone and like, you know, like my messaging app is closed, but I'm sure that like somebody has messaged me about a case, more than one person. And so, um, one of my associates, actually it was a newer one. You're familiar with her. She said something like, I like that you're like kind of like a millennial, like you'll hash these things out over messages. And I was like, well, yeah, and I think it's more efficient, and that is unusual probably for someone of my generation, but like it's just how I work. And so my chats are full of debates about what we should say or what we shouldn't say, or, is there a doctrine that says this, or what do you think of this? And so, my whole life, whether personal or professional, is a back and forth with other people. It's how I operate. I think it's probably what makes me um, a good litigator. Um, I like to see different styles and ideas and pick the one I think is best. And that gets harder over time because it's sort of like I know this and I'm not going to be swayed. But the nice thing is the law changes, so like it doesn't have to be that like I was wrong, and it can be the law is different now, so it's a little easier to accept and seriously consider a different idea.
So you're the co-chair of this practice. It was this hard-won process that, in many ways, was the very thing you're building towards when you first joined your firm. So what could top this? Like, like what could be more gratifying than having achieved what you have? You've got probably decades of career ahead of you if you want it. So what is it that's going to motivate you, or is there some sort of how do you think about a goal or something like that from here? Because is it something substantive like arguing at the Supreme Court, or what is it that is that North Star that is the next level for you, if that's how you think of it?
I mean, that's one thing, is arguing at the Supreme Court. I would love to do that, but even just I don't know. I think we talked about this the last few years. I've really felt my gender in my cases, and it's almost like the more high profile of a case or important of a case, the more I feel it. And I don't know why that is. But I would love to not feel that way. That would be a goal. I don't know how to get there. I think it might be impossible. But uh, one can dream. I applied to be a federal judge a few years ago, and I would seriously consider that in the future. To me, it would be very gratifying. I think I'd be good at it, and I think I'd be fair, and I think it would be meaningful to me in a completely different way than what I do now. I mean, those are the things in my career. A lot of my overall goals are more like personal, like raising my kids, um, to make it so that other women don't feel this way when I have two sons, to make it so that, that's not a thing, although I think it will always be a thing. Um, or, taking care of my parents, or um, making the most of the time that I have, knowing that it's finite. But, in terms of career, I think arguing the Supreme Court, getting more cases where like that are high profile, where I'm the lead and sort of the presumptive authority um, on what we're going to do, because those positions are very hard to get, and they, you know, for a variety of reasons. But I think that I'd feel good about that if that happened more often in my cases. And I can see it possibly moving in that trajectory, so it's not hopeless. Um, uh, I mean, I really enjoy mentoring, and I would love to find a way to do that. I also think I'd be a good mediator, but I'd have to like figure out how do I become a mediator, and that seems daunting. But those are the things that are exciting to me.
I think there's obvious things about becoming a federal judge that are appealing.
Yeah.
The influence you have, the variety of matters you take on and that impact you have on society. Um, what is underrated about becoming a federal judge?
Underrated. Uh, I don't know. I mean, I think just the ability, especially in the area of criminal law, to like have the ability to look at somebody standing in front of me and make an assessment um, about what's going to happen to them is very meaningful. I, I also, I mean, to be clear, there are definitely drawbacks. I interviewed a few judges when I did this before I applied. And it's clear to me that it's not the life for everybody. And particularly right now, I'm not sure, if I were the judges that were holding unconstitutional, executive orders, I don't know. I mean, it would be thrilling in some ways, but it would also be scary in some ways. Just like, you know, leaving the country and coming back as someone who's brown, yes, a citizen, but still brown is also terrifying. So, not terrifying, but it is worrisome. And the fact that I have to worry about is terrifying. But um, I think judges have the ability to help shape the profession in the sense that, when I'm talking about women and men or younger lawyers, older lawyers, some judges have a rule that's like, we want more junior lawyers to argue. I think there's a lot of authority and power in a judge, particularly a district court judge, who has more of an ability to affect the day-to-day life of the people that are clerking for them, that appear before them, um, whether client or not. Um, but and by being an example, that hopefully deters stereotypes.
Well, I'm looking forward to your potential confirmation in the coming years.
It's not going to happen, but that's okay. Maybe, maybe.
Amika, this was exactly what I hoped it would be.
Oh, good.
It's such a great glimpse into your really unique career path, how you think. Yeah, I'm just as of now, get outset. I'm not going to use the S word. I've already said it too many times, but yeah, just I think it's very easy to talk to you, and you have a lot to share that I think it's very relevant for lawyers at any stage of their career. So I really appreciate your direct communicator, as you said. So I just appreciate how much you have to share here, and hopefully we can do this again.
Thanks. I appreciate it.